It's all right. You're good. All right. Are you Maverick Neal? And
Okay, pause, right here. Maverick Neal just got hit with aggravated assault with a deadly weapon, a second-degree felony. That's no traffic ticket, that's up to 20 years in prison. And guess what? The complainant nowhere to be found. So why isn't this case dismissed already? Let's unpack it.
Mr. Neal's charged with aggravated assault with a deadly weapon in 24 DCCR 2436. And what is the announcement?
Judge, we'd reset for me to try to contact the complainant. I'm not getting any answers at written correspondence or the different phone numbers my investigators can locate for. But I'm not inclined to dismiss because of the seriousness of these charges, Judge. I've made a probation offer, which I believe is going to be rejected. And if that's the case, I guess we'll set for trial. And I'll can double our efforts to locate her.
And you intend to go forward with or without?
Did you catch that? The prosecution is ready to move forward even without the alleged victim. Yep, that's allowed if they have enough independent evidence like 911 calls, medical records, or witness statements. It's a risky move, but it tells you just how serious they think this case is.
I believe I can prove the case without her presence, Your Honor.
Okay. So if, sounds like there needs to be a rejection done. If there's not going to be, if he does not want to accept any plea agreement, let's get the rejection done this morning. That's on the tablet, and then I'll call you back up when I'm ready to take care of that.
Anthony Whitmire.
All right, so Mr. Neal, in cause number 242436, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, I do.
And I have here on the computer plea bargain rejection that you've signed with Mr. Doyle. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your case, for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. And with that type of probation, if you successfully completed it, the case would be dismissed and you wouldn't have a felony conviction.
Now here's where things get tough. Imagine being offered a deal. 5 years deferred probation, no jail, no felony record, but only if you say you are guilty. What would you do? Let me know in the comments, because Maverick is on the fence and the judge is laying down the law.
Do you understand? So I want to make sure that you do understand everything, because it's very important that after today, if I put your case on the trial docket, I won't accept this plea agreement. All right. So if you want the plea agreement, fine. If you are not guilty and you want to have a jury decide, that's fine as well. Mr. Nichols has stated earlier today that he intends to go forward with or without the complaining witness in this case. So we've talked about that. I don't want you to think that at some later date he intends to dismiss the case or something would change unless there's new evidence that comes forward. So if you don't want to take this 5-year deferred probation, that's fine. We'll put it on the trial docket, but I want you to make sure you understand that I will not accept this agreement after today. If you change your mind later and you want to enter a plea of guilty, then you can plea open to the court or to some other plea agreement. Do you understand that? And do you want to reject that plea agreement and have your case set for trial? It's your decision.
Sorry.
I mean, go ahead. I mean, if y'all need to talk some more, but
You don't want to plead, correct?
This right here is where the tension breaks through. Maverick looks confused, frustrated, maybe even cornered. He's been back and forth to this courtroom, thinking the case might get dropped, but that hope, it's slipping away fast.
Yes, you want to plead, or no, you don't want to plead. That's what we've been talking about outside there.
so you've been talking about it with Mr. Doyle.
Because I'm not understanding
What are you not understanding?
it's been 4 times.
I don't know about 4 times.
He's talking about the docket call.
Okay.
His state had indicated to me that they might have, I indicated to the state rather, that the victim didn't want to prosecute the case.
Right.
He's never been able to get a hold of the victim.
Right.
To have her tell him that. He feels like he's been up here enough that I have the authority to make the state dismiss it, and I don't.
No, correct. So Mr. Doyle is doing everything he can with trying to negotiate with the district attorney. And it is legally possible for the state to go forward with the case without the complaining witness, and that is what they intend to do, according to Mr. Nichols, correct,
Yes,
Mr.
sir.
Nichols? So with or without her, they're going to present the evidence that they do have to a jury, if you go to a jury trial, and then that jury can decide whether or not you did or didn't do what they're charging you with. So today is the day to decide if you want to go to
Boom. That's the ultimatum. Trial or plea no third option, and the judge made it crystal clear. Today's your last chance. Whether or not the victim shows, the prosecution is pushing ahead. And if Maverick gambles and loses, he's looking at decades, not probation.
trial and let that jury decide whether she comes or not, case isn't getting dismissed, or if you want to enter a plea of guilty to the offense for that 5-year deferred probation. So you want to have a jury decide. Then I will place your case on the trial docket. Mr. Dole will begin preparation for trial.
Okay. Do you have any ideas?
They'll send you that date. We're about
Okay.
3 months or so.
Okay.
Okay. Yes, sir. Thank you. You're free to
Thank
go.
you, Your Honor.
Mr. Bennett didn't have this setting on his calendar, and, yes, ma'am.
We're going on the lesser included robbery.
Thank you.
There are some misdemeanors that are out there that are gonna be, taken care of, so we're gonna need to determine the restitution.
And just like that, we are on to the next defendant. But keep watching, because this next case has its own twist. Another 5-year probation deal, but this time, the guy takes it. You will want to compare how different that courtroom energy feels.
On those misdemeanors, as far as if there's any.
Good morning, sir. Are you James Ward? And Mr. Burbank, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Ward, in cause number 240541, you're charged, the state has elected to proceed on the lesser included offense of a second-degree felony offensive robbery, and that's from April 11th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Burbank? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to pay restitution that would be determined between now and when we come back for sentencing, and there would be dismissals in the misdemeanor cases. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection to one.
It's admitted. Any evidence that Mr. Ward's not competent? All right, sir, I'm going to find that you entered your plea of guilty freely